If you've listened to enough conversations, you've probably heard a lot about law and our legal system. Whether it's a court case, a police officer giving someone a ticket, or even a debate about politics, law is prevalent throughout much of our daily lives. But what exactly is law? What are the most important things to know about it? And why is it so important? It's time for us to find out. Join me for a teenager's guide to Canadian law. In order to fully appreciate our modern legal system, it's important to understand its origins and how laws used to be made in the past. The earliest known codification of laws by humans is the Code of Hammurabi, which was made by King Hammurabi of Babylonia around 1754 BC. The legal system of this time period relied largely on a predefined set of laws. Judges would simply look up the appropriate penalty instead of making a decision themselves. Must have been an easy job. Laws of this time period had very strict punishments. You could be put to death for something as minor, at least in today's world, as accusing someone of a crime without proof. Hammurabi's laws covered just about every aspect of society, from family life to property ownership to wars. While modern legal systems tend to rely more on court decisions as opposed to a strict code, the Canadian Constitution serves a similar function to Hammurabi's laws. Another important area of law to be aware of is human rights. The Canadian Bill of Rights was enacted by John Diefenbaker in 1960. For some reason, he doesn't look very happy about it. History students may remember Diefenbaker as the Prime Minister who ordered the creation of nuclear bunkers, Diefenbunkers, during the Cold War. As a federal statute, the Bill of Rights was subject to change by Parliament at any time, and it only applied to federal matters. It also had very limited protection of citizens' equality rights. When Prime Minister Pierre Trudeau came to power in the mid-1960s, he ordered the creation of the Canadian Charter of Rights and Freedoms.
The moment the Queen puts her signature on this document, it becomes law. It will be witnessed later. The Constitution is now home.
The Charter is notable from a historical perspective because it ordered the review of a number of existing laws. Many previous precedents set by courts had to be reviewed and sometimes overturned due to new constraints set by the Charter. We're now interrupting this broadcast to bring you a 90-second segment on the 10 types of law. No, editor, that image says 60 minutes. Okay, there we go. There are two types of law: public and private. Under public law, there are three more specific categories. Criminal law is composed, unsurprisingly, of laws concerning crime. Constitutional law addresses debates over or changes to the Constitution. Lastly, administrative laws cover interactions between citizens and the government itself. Private law is somewhat more complex. There are 5 categories. Family law handles cases regarding divorces, adoption, and so forth. Contract law covers legally binding agreements. Tort law is the most common type of law that comes into play when someone is seeking damages, that is, retribution, during a lawsuit. Property law is called upon when property is being sold or bought. Finally, labor law deals with issues surrounding the workplace. And now, back to your regularly scheduled program. Thus far, we've been focusing on the general principles of law. Now we're going to narrow our focus a bit to laws which are applied mainly in criminal cases. But wait, you might ask. When there's a criminal, don't the police just show up at their apartment, break down the door, and drag them off to prison? No. It's a tiny bit more complicated than that, just a bit. You see, the police can't just decide to arrest someone and throw them in jail. There are a set of procedures that need to be followed. The first step is to determine the criminal's actus reus and mens rea. For those who don't speak Latin, these represent the criminal's actions, what they did wrong, and their intent, why they did it. Both of these components must be present in order for the situation to be classified as a crime. Let's say that Fred thinks robbing the local bank is a good idea. He shows up at the bank, tries to get in, and then the cops nab him. When the cops find out that Fred recently lost his job, they determine that one possible reason he might have wanted to rob the bank was because he had no money. While they would need more evidence to prove this, the suspicion is good enough for them to obtain a warrant for Fred's arrest. He will be arrested at the scene of the crime and read his rights. There are two types of offenses we could classify Fred's crime as. Minor crimes are considered to be summary offenses. The punishment for these crimes is less severe, and police have to see it happen to arrest the criminal. More serious crimes are considered to be indictable offenses. There is no limit on how long it can take for prosecution to start with these crimes. The police are also allowed to arrest the criminal without witnessing the crime, if it is an indictable offense. We'll assume that Fred was robbing a major bank, such as TD. This type of crime would likely be considered an indictable offense. Depending on the precedent at the time, Fred may or may not be released on bail until his trial starts. Bail allows a criminal to return to their home until their trial, under several restrictions and conditions. Trials take place before a judge and/or a jury, depending on the offense. There are two important lawyers in a trial. The first one is the prosecuting attorney, or plaintiff. They are the one making the accusation. A good way to remember this one is that they are the complaintiff. In Fred's case, a Crown attorney would be appointed for the prosecution, as this is a criminal law case. Crown attorneys are lawyers who are hired to represent the government. The second lawyer in Fred's trial will be the defense lawyer. They represent the accused person, in this case, Fred. Fred may already have his own lawyer, or he could ask for one. All criminals are legally required to have access to a defense lawyer. The trial will proceed similarly to what you may have already seen on TV shows or have read in books. Both sides would present their evidence in a respectful manner. The judge or jury would then pronounce a judgment of guilty or not guilty. If the judgment was guilty, the judge would decide the appropriate sentence. A judgment of not guilty would acquit, that is, release, the criminal. The final topic we're going to cover today is young offenders. What does our legal system do with youth? They are too young to be put in prison, but there is an age at which they should be smart enough not to intentionally commit crimes. Prior to 1984, there was no separated youth court, which led to youth being sentenced unfairly, among other problems. For this reason, Canada created the Young Offenders Act, and later the Youth Criminal Justice Act, which applies to all youth over the age of 12, but under the age of 18. The Act established a separate legal framework for youth charges in order to solve the problem of unfair sentencing. At this age, youth are expected to understand what they are doing more than younger children, but are not supposed to be held to the same standard as a fully mature adult. To finish off, let's summarize what was covered in this video. We started out with a brief review of historical laws, particularly the Code of Hammurabi, with its strict punishments. We then moved into a brief talk about human rights. Then we covered the types of law and types of offenses, as well as the necessary criteria for an action to be considered an offense. Finally, we wrapped up with a brief summary of court proceedings and youth offenses. This video is not intended to be an exhaustive summary of Canadian law. Rather, it is intended to give you a quick yet meaningful introduction to this fascinating subject. If you have any questions, comments, or suggestions, leave them in the comment below. Otherwise, I'll see you next time.